lady who has joined in for today's session. I welcome the expert for today's session, Dr. Kavita, and I also welcome my co-coordinator for today's session, Dr. Rajesh. So, and I welcome all the student participants who have joined in. So, let us start today's session. Uh, As you all know, the Patent Facilitation Unit at NCID IGNOU, this was set up with the approval of the competent authority as per the direction of the MOE's Innovation Cell. And the aim of Patent Facilitation Unit is to ensure awareness of intellectual property rights and patent protection of innovative ideas and initiatives. Some of the major objectives of Patent Facilitation Unit are to create an awareness and understanding related to IPR, especially patents, registration process for filing patents, and other aspects related to IPR protection. It also aims to facilitate IP protection of innovations emanating from the university, whether it is by the students, staff, or faculty members. The other objective is to provide legal, technical, financial assistance to the innovators for protecting their IP. PFU will also do hand holding of the students and faculty members who want to apply for IPR or patent for their innovative work. Now, since it has been involved and it aims to take up guiding and supporting the IGNOU students in IPR and patent filing process, the PFU has been organizing talks and virtual sessions for innovative students of IGNOU to create awareness among them. And this session, which is being organized today, is the fourth in the series of the awareness sessions. And this session is special because we are also commemorating the World Intellectual Property Day. Though the day is on April 26th of each year, it is celebrated on April 26th. We are commemorating or celebrating it today. The goal of this World Intellectual Property Day is promoting awareness of intellectual property and its safeguarding, and to educate individuals on the various methods of safeguarding intellectual property, such as copyright, trademarks, patents, and so on. And the event was established by World Intellectual Property Organization in the year 2000, and it is also April 26 is also the day on which the WIPO convention came into force in 1970. And several organizations plan public outreach campaigns and events, activities to educate people about the importance of intellectual property protection on this day. Public events and programs are conducted to enhance people's knowledge on the subject and promote understanding of intellectual property concepts. And on the similar lines, we have also arranged a discussion session with an expert on patents and IPR, Dr. Kavita, today. So I welcome you all to this session and hope you will find it interesting. And now I would request Dr. M. Rajesh to please give the welcome address.
Thank you, ma'am. Thank you, Sujata, ma'am. In fact, you have initiated the discussions in such a splendid manner that not much of an explanation is required on any aspect. You have given a very good background on the program as such. Basically, to begin with, I would like to emphasize that this time the IPR Day theme which has been put out is very, very interesting. In fact, what is very interesting about this IPR Day 2023 is that the theme for the IPR Day is basically women and IP, accelerating innovation and creation and creativity. So it is a very special occasion on which we have assembled today to discuss about something that is very important, that is innovation, IPR, and how IPR and innovation can actually work towards creating a better world in all its real sense. The World IP Day is basically celebrated, as my colleague was just mentioning, to raise awareness about the importance of IP in promoting the economy, innovation, trade, and many other things associated with the economic sphere. IPs are in fact essential to protect the creations of the intellect. It is my proud privilege today to first and foremost welcome Dr. Kavita Chalakal, Assistant Professor, Inter-University Center for IPR Studies, CUSAT, who has so graciously accepted our invitation to be part of this program in spite of her very busy schedule. We wholeheartedly welcome you, ma'am, to this session. Dr. O.P. Sharma, Director, NCID, I hope sir will be joining shortly, has always been a great inspiration for all of us. And his presence in all IP-related platforms has given us great encouragement. It is my pleasure and privilege to welcome Sir Dr. O.P. Sharma, Director, NCID, to this program. It is my privilege to welcome Josna Dikshit, Madam, and Momita Das, Ma'am, from NCID to this program. Further, I would also put on record the enormous work and hard work put in by Dr. Sujata Santosh, Assistant Director, NCID, who has been working tirelessly behind the scene to make this session a success. I welcome them to this session as well. I welcome my colleagues at Regional Center Vadagara, Dr. Pramila O, and Dr. Praveen Kumara to this session. From the dashboard, I can see that the Regional Director of RC Cochin, Dr. Dorothy, Assistant Regional Director, Dr. Jaljakumari, they have also joined this session. I welcome them also to this session. Finally, I welcome all the students and RC functionaries from across the country who have joined this session at our invitation. And I'm sure that you will take back very positive points from this discussion today, and that will stand you in good stead when you come out with your innovations and the process of filing your patents as and when they occur. I welcome each and every one of you to this program once again. Over to you, Sujata, ma'am.
Thank you, Dr. Rajesh. Thank you so much. And since Dr. O.P. Sharma will be joining in some time, so let us start this program. And I would request you to give a brief introduction about the expert for today's session, Dr. Kavita, and then we can hand it over to her further.
Sure, ma'am. It is my absolute privilege that I get an opportunity to present a resource person of such eminence to our audience. Dr. Kavita is currently working as Assistant Professor at the Inter-University Center for IPR Studies, CUSAT, which is the short form for Cochin University of Science and Technology, which is located in Kerala. She has an illustrious career to boast of. In fact, she had worked formally as Assistant Director Research and Assistant Professor Senior Scale in Lloyd's Law College. She received her PhD degree from the prestigious Jawaharlal Nehru University in the field of environmental law. She also completed her LLM in intellectual property and environmental law from the Cochin University of Science and Technology, and further went on to receive her MPhil degree in public international law from the Jawaharlal Nehru University. She is a bachelor degree holder from the Kerala University. And she also has an enormous experience of working with various government and semi-governmental institutions. She has been instrumental in developing a number of modules for the postgraduate courses in e-Pathshala for the project of Ministry of Human Resource Development, Government of India. And she has also been an active participant in many national and international conferences. And in two very important international conferences, she was awarded the prize for the best paper. Further, she is also a member of the World Commission on Protected Areas and the World Commission on Environmental Law, International Union for the Conservation of Nature. So I can go on and on with her very impressive biodata, but for the short, this is in a nutshell the biodata of Dr. Kavita Chalakal, and it is our absolute pleasure and privilege to welcome you, ma'am, to this program. Over to you, Sujata, ma'am.
Thank you, Dr. Rajesh. So once again, we are eager to hear from you, ma'am. So,
Yes,
yeah, ma'am, though we have apprised the students about the word this intellectual property day, so I would request you to please throw some light on the importance of the celebrations on the intellectual property day. Why is it celebrated, and what types of activities are organized on this occasion?
yes. Thank you, ma'am. So, may I start, ma'am?
Yeah.
Yes. Good morning. Uh, there is an echo. Good morning, everyone. It's a great privilege to be part of this program, and I extend my heartfelt thanks to Rajesh sir, Sujata ma'am, and all other uh, senior members at IGNO for inviting me to this program. So, in spite of that whole introduction, I just would like to say that I'm just a teacher who is interested in teaching IPR, and I'm quite passionate about this subject. So I'll just start with Sujata ma'am's suggestion. So World IP Day, like I'm not going into the establishment and other things, but World IP Day is essentially for identifying ways in which the general public could be aware of intellectual property rights and how they could avail these rights which are statutorily available for them. So when we look into India, I always like taking from an Indian perspective or any other developing country perspective, we can always see that we never had this culture of protecting IP. We never had a problem in sharing our notes. We never had a problem in sharing our assignments. If it is a one assignment topic for five people, they will all share it because we were never concerned about the IP we are creating. So, when an individual level, at an informal level, it is not an issue. But when it comes to commercial level, this uh, disregard, I would say, not lack of respect, disregard to the IP rights would essentially result in the loss of an individual. And in a commercial economy where knowledge is the power, knowledge needs to be protected. There is no question about it. So, this knowledge could take various forms of intellectual property. It could come out as an invention, which is eligible for a patent. It could come out as a literary work or an artistic work or any other work which could be brought under copyright, or it could be a trade secret which you have protected. It could be a trademark which your company has availed a goodwill of. So essentially, whenever we have created something which is worth, we need to protect that. Traditionally, we have been more focused on protecting our conventional tangible property. The moment we buy a plot, we don't leave it open. We immediately build a fence over it. We build a house. We of course will build a door on it. Without a door, what is the purpose of a house? So you protect your tangible property, you protect your traditional property. I think it is very evident when we buy something from a shop, we don't keep it in the open. We have immediately the tendency to keep it in the bag because we have that psychological urge to protect our property, which is very clear in the tangible traditional types of property. But when it comes to intellectual property, we are not concerned. We easily share ideas, we easily share our thoughts. So I mean, those who are in academic circle, we would have come across such situations where you share one area of research with your colleague, and one fine day your colleague would be publishing on it and you wouldn't even know that it happened. So these are the things in which we disregard the adverse effects of not protecting our IP. And World IP Day essentially tries to clearly create an awareness among the general public to show that this is needs to be protected. Please treat it as your traditional conventional property and ensure that it is getting a protection. And to achieve this objective, WIPO, World Intellectual Property Organization, comes up with themes. And this time they have focused on women, their innovation and creativity. So this, I would just give 1 or 2 minutes on it. So women, we know they have contributed so much to science and technology and the culture and art development in any society. But unfortunately, most of them are not adequately recognized by the law or by the society. And female entrepreneurs, we can always say that the gender disparity or the patriarchal structure of our conventional society have limited the women to come out and protect their IP. So the initial issue of not protecting your IP added to the women who are not adequately recognized in their for their achievements has made this thing very valid. Women are multitasking. There is no question about it. You give them a tough situation, they find a solution, and that would be the easiest one. And WIPO essentially wants to create this awareness among the general public to protect the female entrepreneurs and female creators. So I think that is what I would like to talk about the World Intellectual Property Organization celebration of IP Day. Basically, I would say the simple easiest conclusion would be to increase the awareness of IP and to ensure that the domestic legal systems are creating and respecting the IP rights within their legislations. So,
Um,
yes, ma'am.
Thank you, ma'am. Thank you so much for such an elaborate explanation, ma'am. Since there won't be any presentation, I would suggest you stop presenting
Mm.
so that everybody knows that this will be in the form of a discussion and there won't be any PPTs there.
Okay.
And so this will help us.
So, do you know, I was given a couple of model questions. So, does these questions need to be shown, or I can just talk about these questions and
No, you don't have to.
okay,
You may please stop.
yes,
Uh, Madam, that was a very comprehensive idea that you have given about the IP Day. And we have really come to understand why this IP Day is in fact being celebrated and why and what is the logic behind it. Now,
yes,
coming to something more specific, ma'am,
yes,
there are a number of students who have innovative ideas.
yes,
And these ideas are of such a nature that very often students or even more accomplished people do not know what is the patentability of these innovative ideas or innovative processes.
yes.
So one question that normally comes to the mind of most people is whether at the stage of an innovative idea itself, a patent can be obtained. Is it possible
No.
or not?
No. So for that, I would just like to say something. Whenever we have a law, we have an object of law or the subject matter on which the law is created. So when we take patent, the subject matter of patent law is an invention, not an idea. So invention is the result of an idea, of course, but invention is something which is expressed in a tangible form. And the patent law says that invention should be new, it should have an inventive step, and it should have a commercial utility. You cannot prove these standards with your idea. You may have an idea, but unless you express it, you won't know how that particular idea would qualify for a patent. And in the beginning, I want all of us to remember one basic point, that patent is a statutory right. That means if the statute is not giving you a right, you don't have a patent. So essentially, that means to get a patent, we need to follow the statute. And the statute, the legislation, the Patent Act 1970 says that patent is for an invention. Invention is a result of an idea, but the idea needs to materialize. And when we talk about patent and idea, I just want to bring in a small addition from copyright law. Copyright law also has the same question, whether idea is protected. Copyright law also doesn't protect idea. None of the intellectual property law protect ideas. They only protect the expression of your idea, the creation which is the result of your idea. Your idea, your innovation would result in an invention. And then you make an application, the patent office will check whether your invention has a novelty, that is whether it is new, whether it has an inventive step. That means whether it has a distinct advantage over the existing one. So, for example, I would like to say one major case. I'll it's just to make you understand. This was in Novartis case. It is very popular case in the sense that Novartis claimed a new patent, a patent on a new invention which they said is more efficient. So the court asked that medicine, I think it is imatinib mesylate, which is for the stage 4 cancer, making it an essential medicine. So there was already a drug which was patented, which was in the alpha form, and this one is in the beta form, and salt form and alkaline form. So they said this new form is a new idea and this is different from the previous patent. So the court asked, we agree that it is new, but the question is whether it has an inventive step. That means whether the previous medicine and your medicine has a difference. So the court said that unless your product has a distinct advantage over the previous one, here it was pharmaceutical efficiency, therapeutic efficacy, unless you have a distinct advantage, you cannot get a patent. None of this can be proved just by an idea. You need to show them the product, or you need to write down. In patent law, we call it as the specification. You need to give the entire details of your idea, whatever you have gone through, accompanied with the prototype, if any, accompanied with drawings and graphs, and then you need to claim. There is a portion in the specification claiming what is your invention. Only that is given a patent. So ideas are unfortunately not patentable. We have to create something out of that idea, which is in a tangible form for you to get a protection.
Ma'am, I would like to know if suppose somebody has a very good idea, and there are often that we think of something, we feel like sharing it with others. So, what kind of precautions should be taken while sharing your idea with somebody else?
See, that is one of the, yes, I would say that is one of the major issues which is happening in science. And I just said in the beginning, like we share, it has happened to me also. We share something with our colleagues, and I would say I think that paper would really look good if these questions are asked and if these conclusions are done. So in that case, ma'am, I'll answer the question after answering your question. So in that case, my colleague has published much before me, and then my paper has no relevance. The same goes for any patenting aspects also. Uh, we like sharing, we like talking about ideas, and everyone is encouraged to share our opinions. But we have to be very cautious. The first point we need to remember is avoid revealing too much. That is the first point. I mean, these are not legal points, but these are the basic industry practice which we need to follow. First is avoid revealing too much. And second option is, if possible, use a non-disclosure agreement. That if it is an official or a formal association, because associations and research institutes would have research association with other institutions. In that, you ensure that there is a non-disclosure agreement. Most of the time, when you get an employment in a when we get an employment in any company, we are asked to sign an NDA, non-disclosure agreement. So the first one is be cautious, avoid revealing too much. Second is ensure that you are signing a non-disclosure agreement. Third is a bit more formal, at least file a patent application. A patent application can be filed even without finishing your invention. You can file your patent if you are sure that you are going to get your result with a partial specification. You can file the patent. That means you are recognized as a first inventor there. Patent is always first come, first serve basis. So I file a patent, even though it is not completed, it gives me an ownership. And the same goes if you are sometimes when we talk to, we have a couple of PhD students here, and sometimes they go and meet some NGOs and some other institutions. So these students are asked, why don't you share your papers with us? Why don't you share the PPT? And I have told them, don't do that, because the moment you share, if they publish, even as a note, your novelty is lost. So ensure that you publish whatever you can before you start sharing. If you have a trade secret, ensure that it is protected by a contract. So those steps, like legally, you need to take steps. Ensure that the idea remains with you through a proper IP filing process. Then I think precautionary approach is the first thing. Before you reveal to any, like most of the time, investors will come to you and they'll ask you what are the details of your product, how will your product work, how will your software work, how will it how is the interoperability with other things, etc. So before you engage in such discussions, it is always advisable to research the people who are coming to you. Research the person who is coming to you, and then see how much trustworthy they are. Do they have a tendency of stealing others IP? It is very common. I mean, especially there are many instances in the universities. One such instance was where in a USA, in one university, sadly both the people were Indians. Both of them were from Andhra Pradesh. One was a professor and the other one was a PhD student under him. So this student found a new way of administering eye drops. He found an apparatus for that, which he shared with his professor. Naturally, he's a PhD supervisor. And the professor went into an agreement with the pharmaceutical company and they filed a patent, making the professor as the first inventor. You can't do any of this. You know your professor is trustworthy. You have to share because you have an official relation with him. In spite of all this, this happens. But the student, because the patent was published, the student was able to oppose it, and the student successfully revoked the patent, and the professor lost his job because that was a clear theft. So sometimes it would happen in spite of you taking all precautions. Some people may take away, but it is always advised to ensure or just research whom are you approaching, who are you sharing your idea with. And the last thing is document everything. Document everything with a timeline possible. If possible, document with a timeline. So even if you share your idea with someone, I might be working on my invention for last 1 year, 1 or 2 years. I may have my lab reports. I may have my lab entries. Ensure that I am documenting. Documenting is the safest way to prove that you are the first owner or you created the idea. So in a nutshell, I would say avoid revealing too much. Then ensure that your IP is protected as much as you can. Enter into a non-disclosure agreement if it is a formal association. Research your partner to whom you are going to share, and then basically document. Document. That would be the first option all of you should take. And avoid revealing too much. It's always not nice to share things. Ma'am, does that? Yes.
In fact, the next question that I would like to pose to you is something very similar from a related area. Often we have innovative ideas, many of them, and we develop an innovative product also or a business process. But what we normally ignore is to file a patent for its protection. And, in such, I do agree that this is a more casual type of behavior that we enter into. But still, what are the harm that would arise out of this kind of a casual behavior? What is the risk? And I would be grateful if you can also elaborate how important patent protection is for an inventor who has developed an unique product or a process.
Yes.
And if you could throw some light on the difference between product and process patenting, that would be great.
Yes. Okay. So let me first elaborate a bit on the importance of patenting. The purpose of patenting is to give, the purpose of you getting a patent right is twofold. One is to protect your investment so that you are innovating more. Second is to ensure that the public is going to get the patented products. Because if the public is not getting patented products, patent essentially becomes a monopoly, which is not permitted under the law. Patent, everyone calls patent is a monopoly right, and those who know patent will know that patent is not a monopoly right. Patent maximum we can call is a limited monopoly, or more rightly as an exclusive right. Patent essentially protects your investment and it protects your innovation. The benefit of having a patent is that during the term of your patent, which is 20 years from the date of filing of application, During that 20 years, no one else can make the same product which you have patented. That means your competitors are stopped for 20 years directly competing with your product. They can come up with a better product, they can come up with a different product, but the same product as I substitute to your product would be very difficult, because for 20 years the law has given me, the government has given me the right to exclusively market my patented thing, my patented product. So here, it that giving, like, it actually prevents you, or prevents the not filing a patent, essentially means that I don't have an exclusivity. And in such a situation, anyone can take my product and anyone can make it. So I hope I'm not making it too legal and technical, but there was one instance where in 2014, no, 2012, Bayer Incorporation had again a cancer drug, which was patented in India, and they had patented in multiple countries. And this particular drug, it was again for a stage 4 renal cancer, and one course of that medicine would cost around 1,80,000 rupees. One course. So if the doctor advises you for 10 courses of that medicine, you need around 18 lakh, or, like, the amount is not something which is affordable for a normal family. But they only provided a very limited number of that medicines in India, which led to multiple litigations and asking for other licenses, compulsory licenses, etc. But during their hearing, during the trial, Bayer was asked why you are only giving very limited number of medicines in India. Why you are not making it available for the patients? There were around 17,000 patients who wanted that medicine. Why you are not making it in India and giving it to the required number of patients? Bayer said, if we make the product in India, someone else would reverse engineer our product, someone will copy our product, and we will lose the exclusivity which we have made in that particular patent, because they have invested billions of dollars according to them, and they would like to recoup the amount which they have invested. So they are saying, if we make it available in India, India is known for copying and reverse engineering, and we will not do that. If anyone is from Delhi area, you would know Nehru Place. I always tell in my copyright class, if Bill Gates comes to Nehru Place and sees his Windows 11 being sold for 450 rupees, or Word, which he sells 1 year 4,000 rupees, being sold for 200 rupees license, he would be shocked, because anyone can. Or I remember in my JNU days, I'm sure Rajesh sir was also there at the same time. We usually used an unlicensed version of Windows, and by mistake I did an update. And from then onwards, whenever I start my computer, I have this message: your Windows is a pirated version. Kindly activate your Windows. Then I was like, it would get stuck in between. I'm not able to work on my computer. Then one of my seniors in JNU, he gave me a software, and he said that just run the software in your computer. And then after running that software, that particular notification went away. That means even if a company has kept to prevent something from being used without authorization, there is someone who is countering it. So not patenting your thing even gives away your remedy for that. That is a major thing. For example, even though it's a discussion on patent, I would just like to go away, go to other IPR areas also. So, for example, there is this concept of dynamic injunction. Dynamic injunction is a remedy in law which can be availed on a particular, usually you have to have a cause of action, you need to have a person against whom you are going to get a stay and all. But in law, you have this dynamic injunction which helps you to get a remedy against anyone. So when Bodyguard movie was released, it also happened during the World Cup, which was relayed by the Geo channel. So they went ahead and got a dynamic injection saying that this is our IP. Anyone who is using it, we don't know who it is. Anyone who is communicating to the public, I don't know whether it is Ram or Lakshman or Sita or anyone who is using it is infringing upon my right. That is only possible when you have a right. And for that right in your invention, you need to get a patent. Because unless you have a patent, you don't have a remedy. You have remedies, of course, you can go for cheating and other things. But specific remedies, quick remedies are only available if you have a registered statutory right. So if you have an innovative idea and if you are not registering it, essentially you are waiving off your rights and remedies. So the first adverse effect of not patenting would be one, not getting a priority, not getting an exclusivity. Second, it will allow others to copy your product, reverse engineer your product, or free ride on your product, and essentially your commercial income goes less. And thirdly, and most importantly, your rights are being affected. Now, coming to the second part of the question, I think it is the distinction between product and process patent. So I usually take this example because it's part of our syllabus also. I usually take this example: 3 plus 3 is equal to 6. So 3 plus 3 equals is a process. 6 is the product. Now the product patent protects only 6. That means I can reach 6 by 5 plus 1, 4 plus 2, 2 into 3, or 12 divided by 2. All of them would give me 6. So I can use any other process. Sorry, I can use any process to reach 6 if it is only product protected. So that means if there is a medicine, for example, I'm sure all of us know this medicine called ranitidine, which is an antacid, which most of the doctors prescribe when they are giving us an antibiotic. 10 years back, we had multiple generic drugs, Rantec, Rantidine, Rantil, etc., which were actually reverse engineered because at that time India did not have a product patent for that particular drug. So if the product is not protected, you can reach the product in multiple ways. Only thing is that you should not use that process. On the other hand, if the process is protected, the product automatically becomes protected. And then it is basically saying that you have a patent protection for a particular process and you have a patent protection for the product. And sir, can I just discuss on the rights? I think it will be easy to understand if I'm discussing the rights on this.
Yes, ma'am. Yes, ma'am.
Yes. So if we look into the rights of a patentee, when it comes to the product patent, you have the right, if you are the patent owner, you have the right to prevent others from selling, offering for sale, offering for renting, etc., of your product with to your permission. That means any commercial activity on your product without your permission is considered as an infringement for which you have a remedy. On the other hand, if it is a process patent, right now no one else can use that process and no one else can create a product which is the direct result of the process also. So in product patent, you have the product entirely protected and the commercialization of that product prevented by the law. In process, you have the process protected along with the direct result of the product. So in my previous example of 3 plus 3 is equal to 6, the entire thing gets protected. No one can use another process to reach that product, or no one can reverse engineer the product to identify a new process. And this was not the case in India. In India, when we got independence, our major concern was health security and food security. And the British Patent Act was not feasible or was not supporting our developmental policies. So Nehru established a couple of committees to look into the patent law and suggest changes which would promote the technological growth, the scientific growth of our country. And there was one Ted Chand committee which could not realize because by that time the first Lok Sabha came into an end and the bill lapsed. Later on, he engaged one Supreme Court Judge, Justice Rajagopala Iyengar, who came up with one of the famous report, and I would always say that is the Constituent Assembly debate similar thing for patent law. So Iyengar committee found that the patent law in India is not suitable for the Indian development. And he said, to ensure the health security and food security, we should keep two things out of product patent. That is pharmaceuticals, and agrochemical products. So from 1970 to 1995, we allowed anyone to reverse engineer because the product is free. Anyone can reverse engineer and find another process to reach a similar product. And this led to the growth of India as the global pharmacy of the South. Indian generics are the most famous. So essentially, the product patent and process patent has that impact on affecting the development of your country. But and I won't say
Now
unfortunately,
it seems we are going out. Uh,
no, our entry into WTO, I'll just end. Our entry into WTO mandated that product patent and process patent should be granted to all types of invention. There is no reverse engineering, there is no copying possible as of now in the patent law.
Ma'am, could you please tell us something about Patent Corporation Treaty and how
PCT,
what
Patent Corporation Treaty 1970. So when we apply for a patent, you have two ways of applying for it. One is in patent lawyer language, one is Paris route, the other one is PCT route. I'm not going to the technical part of it. Paris route is basically you want a patent in India, you file in India. You want a patent in America, you file in America. You want anywhere, you go to that specific country and file. That means you have to file in multiple countries simultaneously because filing in India doesn't ensure your protection in USA. You need to file there also. And imagine filing in China where we need more Chinese translation and all. This creates a lot of logistical issues. PCT came as a solution for that. PCT is actually a single window system for patent application. You can file your patent application in one designated office. In India, we can file it in the New Delhi, New Delhi Patent Office. And from there, we can designate how many states you want the application to be forwarded to. So PCT accepts your application. It does an examination report. It also advises to what extent your patent application is going to be successful in many countries. You have to pay, of course. It is slightly expensive.
in a way, how has this Patent Corporation Treaty helped the various countries and also the people who are?
It is not actually helping the countries, ma'am. It is not helping the country. It is helping the applicants.
Yeah, that is what I was trying to come
Yeah.
to.
So that's what I am applying only one. I apply in one office and I designate the countries to which I want to send my application. PCT will send it to those countries, but then I have to follow up my activities there. PCT will not follow up once it enters the national phase. I have to pay the fee and follow it up. But I don't have to go to multiple countries and file according to their own things.
I hope this must have made the things clear for our students.
Yes, ma'am, I think we can equate it with applying in multiple colleges at the same time and a single window application. That's it.
Yeah.
Thank you, ma'am. That was very instinctive. And the next thing that we would like to know is what kinds of inventions can actually be protected by a patent?
I think in the previous answer, which I went a bit elaborate, I have answered that, but still I would like to say, as per the Indian Act, a patent is available for an invention. An invention should be new, it should have an inventive step, and it should have commercial utility. And it should not be excluded under Section 3, that is plant, animals, human beings, against public morality, traditional knowledge, mathematical formula. There are multiple exclusions under Section 3, and any atomic related invention is also not patentable. So there are standards to be fulfilled and there are exclusions to be careful of. So if it is not excluded and if it fulfills the standards, any product or a process in any type of technology can be patented. But the term is patent is for an invention in any type of technology for product or process.
Ma'am, to add on to this, I would like to know more about this. Can we get some design, block diagram, or flowchart also to patent it?
No.
Okay.
They don't qualify. Ma'am, the concept is we need to know the standards. It should be new inventory step and commercial utility, and then it should not be under exclusion. With that premise, if we look into diagrams and this thing, these are not inventions. They are essentially artistic work. it would be protected under copyright law.
So they come under software algorithms and flowcharts. They might come with software
Yes, yes.
applications that are designed.
See,
So
ma'am, you
are
asked
they
about,
covered by copyright laws, or they have to?
that's what ma'am asked about designs, block charts, graphs, and software. Right. So designs can be protected under a different law. Industrial Designs Act is there. So the external appearance, including fashion design, can be protected under Industrial Designs Act. Graph, chart, maps, flow charts, etc. will fall under copyright law. It could be either as a literary work or an artistic work. And then we have one area which you said, that was software. So in India, it is slightly distinct because in India, international law on IP says you can either give a patent or a copyright for computer programs. India gives copyright for computer programs. USA gives patent for computer programs. However, in India, if there is a difference between computer program and software, easy to understand is that multiple programs make up a software. So the software is like, Microsoft Office is a software, but the underlying algorithmic codes are programs. So algorithm is not protected because it is common language. Whatever change you have made, you can protect it as a literary work in copyright in India, not in patent. But the application of the software to a machine can be patented. So we call it computer related invention, ma'am.
So, like students are developing software, unique, innovative software applications, mobile apps. So, and some at times they are developing new methods of doing business. So, what should they do? They cannot apply for patent as you are suggesting them.
Methods of business, methods of business is excluded. There is no option. Methods of business is excluded from any level of IPR. Neither copyright or patent is available for business methods. In business method, then therapeutic methods, agricultural methods, all type of methods are excluded. Now the question is with regard to computer software. So as I said, the program, which is basically object code and source code, can be protected as a literary work in copyright law in India, not as a patent. But if the software which the program is made of, software is applied to a machine, which a computer, you can get a patent on it as a computer related invention. There is a patent there, but not for the program, but for the computer program, including the apps. Apps are basically softwares, so that can be patented because it's a computer related invention.
Thank you, ma'am. One of the aspects that often comes to our mind with regard to patenting is that often there are improvements made on patents. There is a previous inventive step which has been improved upon by a second company or a second group of researchers, and then they go in for patents. So, can such patents be awarded for improvements on earlier patents? One, and second, then what is the standard of proof that is required in such cases?
Okay. So essentially, I think we need to understand there is this concept of evergreening of patents. That means companies make a minor adjustments or a minor improvement and claiming a patent on the second one. Most of the time, laws are not supporting this concept that a minor improvement would result in a patent. That means I have 20 years, I'm getting another 20 years, essentially making it a monopoly, which is not encouraged by law. On the other hand, sometimes the inventive step is of such a standard that it has enhanced the efficacy of the product. So, for example, I took a tablet maybe in 1995. If I took a tablet for fever, it would take 4 hours for my fever to subside. On the other hand, if I am taking a tablet now, within 10 minutes my fever is subsiding. That means there is an increased therapeutic efficacy in the new product, which is an improvement of the old product. Or when we look into our day-to-day life, we know how swiftly we came from landline, that is from the landline to the digital phones to the smartphones. Remember the feature phones where we had only numbers and 3 letters linked to each number. If we want to send a message, we need to press 3 One, look how the technology improved. But the concept is basically the phone, it is a telecommunication device. But the inventive step which had happened on that particular device is amazing and immense, that you have to identify that it is a new product. We can't call it, oh, this is a smartphone which existed, the phones existed earlier also, so this doesn't make a difference. No, the inventive step becomes very crucial, and that inventive step, which is a standard for patenting, says that it should be an improvement, a significant improvement on the existing product. Now, with this background, I should say that countries vary in their practice of getting patent. In USA, such improvements will easily get a patent. Their standards of novelty, inventive step is low compared to that of in India. In India, as I said, we believe in making things available for everyone in an easy way, affordable way. So we have always followed a policy where the patent, somehow we see patent as a bad thing, and we ensure that the patents are only given in a limited number of cases. So 10 applications, as you said, with improvement or additions filed in US would result in at least 8 of them getting a patent. Filed in EU would get at least 6 of them getting a patent. Filed in India would result in maximum 3 getting a patent. Because the standards we keep for identifying what is that inventive step is very high. And all multinational companies have a problem against India on this. Now we are trying to lower it so that there is more options for the patenting to happen. But essentially, our standards for patenting is comparatively higher than many developed economies. And our purpose is to keep it available for the public so that it is accessible and affordable. But there, the policy is different because US has a policy of protecting the private rights. India is more into a welfare socialist state. So the ideology difference reflects in the patent grant number also. So the inventive step is very important when it comes to a new version of an old product.
Okay, thank you, ma'am. Can you, of course, you earlier mentioned about the aspect of paying fee to get a invention patented. What is the normal fee that we have in India for filing a patent?
Yes.
And is there any financial support that, for example, startups or other institutions get for this process of filing patents, as well as for remediation of fee in this case?
Sir, may I share the screen for 1 minute because I need to show the schedule. So patent.
Sorry, ma'am. I would request that before moving on to yes, in addition to this, could you also reflect on the process of patenting also? What is the process? What are the different steps and stages involved? And then you can reflect on the fee associated with
Actually,
it.
I had arranged my questions in such way that I'll talk about who can file a patent once and how the patent is to be. What are the stages very quickly? So,
that will help the students also.
Yes. So, when we talk about the question, first question is what we need to answer is who can file a patent. A patent can be filed, like a patent application can be filed either individually or jointly. That means there can be more than one inventor. But the premise is that inventor should always be a human being. Only a human being can be an inventor, making artificial intelligence out of patenting structure. So only a human can be an inventor, and the first person who can be the inventor applicant is the true and first inventor. Whoever has invented can apply. Then in case he has assigned that right to someone else, that person can apply. In case the inventor passes away before filing an application, his legal heir can apply. So once your patent application is filed, the patent law has certain forms. You have to go according to the form. So the form 1 gives your details for the patent application, and once you file the patent application will be kept in the patent office for 18 months. This is the time for us to make any changes in the discussion or specification and all. We can make any amendments required. After 18 months, the application will be published to the general public. That is the time when general public can oppose, because someone is going to get a 20-year exclusivity on that invention. So that is the time when you can oppose the patent application and get it rejected. That means we call it by pre-grant opposition. It is called a pre-grant opposition. Now, if there is opposition, the inventor has to answer the opposition. If inventor is not successfully defending his invention, application is lost. If the inventor successfully proves his invention, or if there is no pre-grant opposition, it will go to the next stage. That stage is known as examination of your patent application. Here, the patent office will look whether your invention is new, whether it has inventive step, whether it has a commercial utility, whether it is excluded. It will do all these checks. And if it passes all these checks, it will go to the next stage, that is grant of patent. If your application fails, then it is refused. And after grant of patent, we are given 12 months to oppose even the grant. So India is a rare jurisdiction where we have pre-grant opposition and post-grant opposition. If there is no opposition and it is only for 12 months after the date of grant of patent. If there is no opposition, your patent is final. It is considered as, we call it sealing of patent. Your patent is sealed with this particular process. This is a quick process in which the patent is granted. Usually, following the strict timeline, you would get a patent from 28 months to 32 months. But sometimes some areas are very quickly given, because during COVID, there were instances where the patent was granted within 14 months also. The patent office was very quick in processing the applications, and in the absence of oppositions, everything else was done fast. Now, coming to the application process is what we need to know about the fees. So, patent fees is, at every stage you have different set of fees. So, there is a classification of applicants, and the fee varies according to the application, application of the nature of the applicant. Just a minute. So this is available online, where you can see that e-filing has a particular fees and physical filing has a different fee. So they have classified natural persons, startup, small entities and educational institutions as one category, and sorry, that is 1600 rupees, and in multinational companies and others 8000 rupees, and it goes, and then this is the filing fee. Please see, this is the patent application fee along with form 1, and once your filing is done, you have to give fees for each of the claim. Filing a statement or undertaking under section 8, you have to, there is no fee for that. Then for examination, you have a fee. You have post dating, you have to pay fee. So in different sections, you have to pay the fee. But essentially, you need to understand that as a natural person, your fee is 1600 for e-filing and 1750 as the initial stage, and it goes on. And when multinational companies, of course, it starts from 8000 for e-filing, 8800 for physical filing. But startups, as Rajesh sir had asked, DPIIT has come up with multiple programs where the startups are given an exemption. And if you file for a patent, they actually reimburse your patent filing fee. They don't waive the fee. You have to pay the fee, but it will be reimbursed for you. So it is not that you don't have enough money to file an application that you are not filing. So they say that you file an application, we will reimburse the fee to you once it is granted. So the startups are given, along with the tax policy, along with the tax credit system, they are also given the IP facilitation, where they can reimburse their amount which they have paid as the patent fees. This has been provided by the Government of India. Especially the startup scheme, I think last 4-5 years, it has been very actively pursued by the government and very easily availed by the applicants also.
Ma'am, there is one more thing which comes to our mind, like what is the time period for which the patent protection is granted, and what should we do after the patent is granted to us?
I'm not clear with the second part of the question, ma'am.
Means, suppose I had applied for a patent and the patent is granted to me. what should I do with it? Means what should I?
Okay.
Because
Okay.
as a young or a new innovator, we don't know how to go about
Yes.
patenting.
I got it. So what we can say is that patent is granted for a period of 20 years, ma'am, and this 20 years is calculated from the date of filing of application, not from the date of grant of patent. Date of filing, section 53 of the Patent Act says that from the date of filing of application, you have 20 years. Sadly, very sadly, I think last year, one application which was on software, Indian Patent Office granted it after the 19th year from the date of filing of application. It went into multiple litigations and all. So imagine you are getting 20 years from the date of application and your patent is granted on the 19th year. But that is an odd case. Usually, once you apply, you will get your patent within 3 to 4 years. That is a normal window of grant of patent, and you have 15 to 16 years to commercially exploit your patent. So, patent granted and 20 years is not the rule. Patent filed and 20 years is the rule. Once you get a patent, you have two options. One is you can commercialize it. That is the purpose of patenting. You can make money off it. Or if you are not interested, you can actually what we say, you can actually look into the assignment process. You can give away your patent right if your invention is very good. You can sell it. It is a transferable property, like a traditional property. Your patent can be sold, it can be assigned, it can be licensed, so it can be transmitted. So if you are not interested in it personally, you can move it. So I would like to give a very quick example. I think we all remember the good night mats which we used to have, that right, like we had a tray type of thing and we push a mat to it, one rectangular type of mat, and then it developed into the liquid thing. So the person who invented that mat type of thing, he said, I'm not capable of commercially exploiting it in such a big scale. And I'm saying, I think it went to P&G then. They developed multiple technologies on that. So you can sell your patent also if you are not capable of, or if you are not interested in doing it. So that is the second, like first option is you commercialize it. Second, you give it to someone so that they can commercialize it and you get the money. Third is you become altruistic and you surrender your patent. So, for example, Jaipur legs, that particular process and the thing is not patented. He wanted everyone to be able to use it. So, you can be altruistic and you can just surrender the patent so that it becomes part of public knowledge. Or if you are very adamant that I hold my patent, I will not make it available for the public, the government will take it away. Under the act, it will revoke your patent. And if you are, again, there are two options before revoking. If you are saying that I will not make it available, others can approach for a license. And if you are not giving a license, the government will grant a compulsory license, or it will revoke your patent. This is what happens after the patent grant. I think the best way would be commercializing it, making money out of it. Is that clear? Yes.
Yeah, that is in fact very well explained, and that gives us a lot of ideas about how patents should actually be utilized in the market as well. But there are cases in which there are conflicts between the persons who have patented a particular invention and others who come in and just reverse engineer or do some negative activities and then go into the market and bring in their own version. So how can actually a patent owner prevent others from commercial violation of their rights?
So the Patent Act actually gives you the right to prevent others from selling, using, offering for sale, etc. of your product or your process and the direct product of your process. So Section 48 gives you very established rights, that is to prevent others from using your patented invention. Using in the sense for a commercial purpose, okay. For research purpose, you can use interoperability, you can use, it is not an infringement. But if the moment you are making money of it, you are infringing the right of the original patent owner. In that case, you have the remedies. You have the civil remedy and the criminal remedy. Civil remedies include injunction. You can stop, you can apply for a stay, approach the court and ask for an injunction preventing the other party from doing it, which could be a permanent injunction, which is after the final decision of the case, or a temporary injunction, which is during the case. Like the case has started, and I want a temporary injunction. So the temporary injunction would be valid till the decision, and the temporary injunction would become a permanent injunction if there is a proof of infringement. That means I am stopping anyone from doing it. Then I can claim the profits he made out of my invention. So ma'am has an invention, and I made a profit out of that particular invention without ma'am's permission. So she can ask for the accounts of profit I made, and I have to pay that amount to ma'am. It's called accounts of profit. So the court will ask, I cannot say I did not sell. The court will ask for my data, and whatever profit I have made, I have to give it to ma'am. Or as a criminal remedy, I can be fined. I can be fined for using that particular property. Sir, am I clear?
Yes,
Yeah,
ma'am.
very much clear. Ma'am, there is one more thing that comes to our mind when we talk about patents, and that is the territorial rights, which are which are granted in a country or a region. Could you please elaborate,
Okay.
throw some light on this aspect of the
Yes.
patents also?
Yes. I may just have to step out of patent law for 1 minute. So in international law, we have this principle of territorial sovereignty. Territorial sovereignty means a state has complete sovereignty over its territory. That means no other state can intervene in your state. So that essentially means that your laws cannot be applied in any other state. And I started this discussion by saying that patent is a statutory right. And a statute is only valid in the territory of the state in which that statute has created. So Indian Patent Act is valid only in India. US Patent Act is only valid in US. So whatever rights you get, it is a territorial right because your remedies and rights are only available in India. If I have a patent in India, but I do not have a patent in China, and if someone is using my invention in China, I don't have a remedy because I don't have a patent there. Someone is using my invention in India without my permission, I have a remedy.
Okay, ma'am.
That is territorial consent. That means my rights, my rights and remedies are essentially in the territory of the state in which that particular statute is there.
Fine. Which essentially means that international conventions do not have an overriding
No,
influence.
international conventions provides a standard for the states to make law. You have to make your law according to the standards given under TRIPS or Paris or whatever WTO says. But the law is made in India for your state, and only you are responsible for that. And on this, what we say, there is one exception in IPR for this, that is well-known marks. Some trademarks are so known internationally that they get an automatic protection in other states even without registration. So, for example, Honda is a well-known mark. Even if it is not protected in India, everyone knows that Honda is Honda. So, it has that what we say status of a well-known mark. So, even in the absence of a registration, you can get a remedy there. But that is common law remedy, not remedy under Trademarks Act.
Fine, ma'am.
Yes.
That is really a very instructive and very well explained. In fact, the next question that I am going to put forth to you is something that you have touched upon briefly, but maybe a bit of elaboration could help on this aspect. Can patent owners grant the right to use the patent to other entities?
Yes.
And what are the general conditions in this?
It can be given as a license, like you have a provision for transmission and assignment of your rights. If I'm not wrong, it is in section 63 of the Patent Act, where it says that you can actually transfer your rights to other people, and 69 actually. And this basically says that it has to be through a formal process. There should be a written agreement, and this written agreement could be in the form which is given by the patent rule itself. And once you are completing it, you have to inform the patent controller, and the patent controller would make a record of your assignment or your license or your sale in the register they keep in the office. and it has to be formal and official. And informal without agreement is not possible for, like, of course it is possible, but it is not valid as per the law.
Keeping in mind the restraints of time limitations we have a few more queries, means one or two. If you could briefly tell us about that also, because whenever we are into patenting, so you have spoken about it. There is an issue of publishing also related
Yes.
to it. How one should go about it? Should one publish first and then apply for patent, or should one apply for patent and then then start writing about it? So could you please briefly tell our students something
Yes.
about it?
So patent, again, the problem is novelty. It should be new. That means no one else should have written or thought about it, including you, in a public sphere. So publication before patenting would essentially, if I publish details of my invention, you can actually replicate my invention. My novelty is lost. So it is always advised the day you file your patent application, the next day you can publish. But always file and publish, because pre-publication of before your filing would result in someone else using that information to a single product into the market, would result in the loss of your novelty. And if your novelty is not there, there is no patent. So it's always advised that you publish only after filing your patent. Even provisional filing is fine. You don't have to give the complete details. Just a provisional filing, ensuring that you have the first ownership.
Thank you,
And
ma'am.
publication is good because it gives the visibility to your product after filing, not before filing.
Thank you so much, because students are we ourselves get confused whether if we have something, we have a product or a process, should we publish it about it first, or should we say go for patenting first?
Yes, the problem is only that we lose the novelty with publication and it would affect your application. It will be rejected in the 18 months itself.
Fine, ma'am. That is a very important piece of information, and very often those who are in the academic field, they get confused with this because they feel publication is the first and foremost thing that need to be taken up.
Yes.
One final question from our end, ma'am. Take into consideration the time and also the fact that some of the students may also wish to raise some questions. We are in the these days we hear a lot about startups. There are a lot of startups coming up. Unicorns are the big word in the field of business.
Yes.
So, given this fact, when we consider startups, they have several stages, like the idea generation stage, research and development stage, stage, early stage, growth stage, then investment stage, so on and so forth. What are the essential considerations that a startup on the whole should keep in mind with regard to their IP?
Yes. One of the mistake, I think it is a cultural thing, but we are changing it. We somehow, even for startups, they are not very cautious about their IP strategy. Like for example, it might be a very small thing which you created. So you have this crate coconut which is very available, like you have that. Some SME started packing it and selling it, which became very popular, and the name became very popular. And once the name becomes popular, another person started selling it, creating a direct competition, and the second person went and trademarked it. The first person did not do it.
This is so true, ma'am. This has
Yes.
happened with some of our innovative students. They've mentioned it because they didn't think of patenting earlier. They didn't think of
So
getting their copyright, their trademarks protected. So they
yes,
didn't start facing.
we don't understand the importance of trademark, because you have been in the market, created a goodwill, and someone else took it away. This could even happen in the domain name registration, like this igno.co.in. Like if someone else registered that, Igno has to buy it from them so that they can protect their website or someone else is not misdirected. So the first thing a startup needs to know is that when they are conceptualizing their business, their commercial idea, they should complement it with an IP strategy. I would say even before starting your business in a commercial manner, get your IP strategy in place. First thing, trademarks, get it registered. No question about it. It should. Trademarks and trade name, which is different. Mark would be the mark and the name would be the name of your business. Get it registered, first thing. Second, in the beginning, we have that tendency to keep it free and open so that we get more clients. But then how long will you give it free? An investor coming in, like at startup, like you may have money, but most of the time you need external investment also. An investor coming in would ask, why have you kept it for free? What am I going to make out of my investment if you're giving those for? So we have the tendency to keep it open source. That needs to be prevented. So first one is securing your IPs as much as you can, which include the previous question, what all you should be careful of before revealing unnecessary ideas to your competitors or your collaborators. Second is, first is trademark and other IP, you need to be cautious. Second is keeping the open source in a proper way. Third, most important one is trade secret. Someone had also raised a question on trade secret in the chat. I hope this would answer that portion also. Trade secret as such is not governed by any intellectual property law in India. It is governed by Contract Act, non-disclosure agreements. So couple of your friends comes in, you trust each other, you are all born from the, like, you are like born from the same mother, one heart, one multiple body, one heart doesn't work when it comes to money. You have to have a non-disclosure agreement in place so that even if they leave, they don't take your business secrets with them. And trade secret is not just some medicinal formula or something. For example, Google algorithm. The Google search engine algorithm is under trade secret. It is not under patent, because if it is patent, it will come out after 20 years. So they don't want it to come out. So they keep it as trade secret. So ensure that your information is protected through non-disclosure agreements, which is governed by the contract law in India. It is not governed by any IP law. It is contract law and non-disclosure agreement. So that is the third thing. After trademark and restricting yourself from keeping everything free, your IP as a free, then the next is trade secret. And the next thing is, you always need to manage and monitor your IP. Sometimes we don't look into the enforcement and management of our IP. Let us say, I'm sure most of us use the software app Telegram. We all download things from that. Who keeps a watch? We go and take photocopies of entire books. Who keeps a watch? No one is keeping a watch. So unless you want your IP assets to be protected, you need to ensure that your strategy is covering the management and what we say monitoring of your IP assets. And major thing we need to understand is, before a foreign investor or a national investor is approaching you, they will ask if you have an IP strategy or not. If you don't have an IP strategy, they will be very reluctant to invest in your company, because their assets are not protected through a formal statute system. So these are the major things. I think an IP strategy in place. Ensure your basic IPs are protected, including your marks and your names. Don't keep your softwares or codes which you are created as an open source, because at one point of time you have to change it back into your private property. And ensure the management and your IP assets are monitored well. And the investors are also presented with an IP strategy, basically. What is the plan of your business? When are you going for a patent? What is the implications of your invention? You need to be very cautious of that.
Thank you so much, ma'am. You have given such a comprehensive viewpoint on all the small aspects related to patenting, which are very crucial, and the budding innovators, they want to know about it.
And most of the time it is in our everyday life. These are the things which we come across.
Very true. But the thing is, we all of us are not aware about these things.
Yes.
The other thing is, since we have only 10 minutes left for this, so we can take only one or two questions from the students.
I will see if I can give quick answers. We will address all.
Yes, that will help. So if you have any queries, because she has already answered so many aspects related to teaching. Any questions, you can please come forward.
Let's see.
I think the first Mr. Raj has raised his hand.
Yeah.
Roshan?
Hi, ma'am. Hi.
Yeah.
Yes, go.
So, ma'am, my name is Roshan Siraj, and I'm from Kerala. So, I'm running a robotic startup in Kerala. So, when I approached the Kerala Startup Mission for filing a patent, they said that I want to find a patent attorney. So, I don't know where to find a patent attorney for filing my patents.
Can I give you a very valuable suggestion in our center in QSAT, our this Inter University Center for IPR Studies? We have a patent facilitation center. We facilitate individual entrepreneurs and universities to file their patents. So if you want, you can contact our department, and we have a patent agent, two patent agents who would help you in filing your patents. If you want, you can. I would like to help you on that. They will give you the all necessary instructions and how to go about it.
Okay, ma'am. I will visit
I'll
there
do,
by person one day.
like I'll do one thing. Let me just give you my email ID. Sorry, not ID, my phone number. So please, you can give me a call, and I'll connect you the person concerned.
Okay, ma'am. Okay.
My
I'm
phone
also
number is
having.
in the message box. Just copy it and give me a call after the class.
Okay, ma'am. Okay. I'm also having a doubt. So currently, I'm running a robotics company, and we are having a complex system.
Mm.
So we are in its prototyping stage, and we are thinking to file its patents.
Mm.
So since it's a complex system, so for making it as an easier thing, let's divide the system into hardware and software sides. So
Mm.
in the software sides itself, we are having a different a lot of sections.
Mm.
So, should we patent these sections as an individual section, or should we patent it as a whole? And the cost of how will the cost of this patent will differ?
Individual patent is, see, whatever is your invention, the fee is 1600 filing for online. And being a startup, your fee would be reimbursed by the DPIIT. The startup mission is there by the government of India. But the question as to whether it should be patented as a whole or as an individual unit, you have to check what is the commercial viability of each of these things which you want to patent. So you may have to file multiple patent applications because you have multiple things in a complex system. So claiming it as a whole might not be the best idea, but let me say I think the patent agents would be in a better position to help you on that, to work on that. So
Okay, ma'am. I will definitely call you.
yes, thank you, Roshan.
Thank you,
I
ma'am.
hope I was of help to you, and I'll connect to you to the person in charge.
Okay, ma'am. Okay.
Thank you.
Kamal
Thank you.
Sarkar had raised his hand. Kamal.
Hello, ma'am.
Hi.
Am I audible?
Yes, you're audible. Please ask.
Uh, Actually, I wanted to know about trademark registration and around New Delhi. If you have, like you have mentioned previously, any service regarding this trademark registration? Because, and another question is, there is a service in Ireland, but they have no registered website, or like it is available on their portal, the name of the service, but I just want to register a company with that name. So is there any problem with that name, or the trademark registration,
If
or the business name registration?
yes, a trademark is registered based on two standard. One is its distinctiveness and its graphical representation. So when we talk about distinctiveness, the concern is whether yours is distinctive from the existing trademark. Just because you told me that the name is already there in Ireland, even though it is not publicly available, that means you are aware of the name. So you cannot claim an innocent use of the trademark. Innocent and simultaneous use would happen when it is not very popular and you used it in that. So the next question is, if it is registered in Ireland, can you register in India? If it is not a well-known mark, and if it is not registered in Ireland, you have a chance of getting your trademark registered. But then the presumption of innocence would be lost because you are already aware of the name. Just because it is not present in India, you are trying to appropriate the name that might not be permitted by the trademark registry. But the word could be same. You can have a different, what we say, that the word letter M has been trademarked by McDonald's. Some other person also may have. Mitsubishi, Maruti has an M. There are Mitsubishi has an M. Each of these companies may have the same letter, but it is represented in a different way. So if you are able to create your trademark different from what is the Irish trademark, you may get through. Otherwise the presumption of innocent use is lost because you told me that you know it already exists. Services are also
Actually,
come in one
actually,
second.
ma'am, I have.
Yes,
Okay.
service marks are also registered under the Trademarks Act. Please continue.
Okay, sorry for that. Actually, I have confirmed that there is no trademark registered with that service name because they have only mentioned that service name in their website.
Then
Uh,
you can of course go
so,
ahead and register. And if they raise a challenge, they will not have an infringement remedy against you because they have not registered. They may have a common law remedy against you, but since it is not a well-known mark, the common law remedy will also not work. So you may go ahead with the registration.
okay, is there any attorney in around New Delhi?
Trademark you can approve. You have a you what whether I know a trademark attorney, that was what you asked.
Yes.
Yes, I do know someone. I can refer the person to you. Again, my number is there. Give me a call in the afternoon and I'll suggest the lawyer for you.
Okay, ma'am. Okay,
Yes.
thank you so much.
Thank you.
Thank you, ma'am. Any other query?
There are two questions. One was trade secret, which I have addressed already. Another one was on the 19 years case. I need to find it out. Maybe I'll inform
Yeah.
Rajesh sir of the case, and I hope Rajesh sir can inform Anup Kumar Prasad on that. I just need to check. I just need to Google. Then I think that is the questions. I think those are the questions.
So, if there are no further questions, then we will be concluding this session. While concluding the session, first of all, I would like to thank the expert for today, Dr. Kavita. Thanks a lot for giving such a comprehensive viewpoint on all the basic issues related to patenting. And we got to learn so much from you, ma'am, today, and so many of our queries and doubts have been answered. We are really very much thankful to you and hope our students might have gained immensely uh, with the information that you have provided. And Dr. Sharma, Director NCID, has joined in. I would request Dr. Sharma to say a few words if possible.
Thank you, Dr. Sujata. In fact, I'm sorry I could not join in time because I'm at home in some personal engagement. But this part I listened, and I have earlier also listened Dr. Kavita. She speaks very well about this. She's expert of IPR that I can understand. And one thing that Sujata you can do, you can involve her in a patent facilitation unit of IGNO and get her guidance because there are certain specific issues which our students want to be addressed. Because in this kind of common gathering, each and every issue cannot be addressed, and that's why I'm suggesting you to kindly be in her touch and try to address and try to solve those individual issues. She has already offered to be in contact with our students, and I hope they will connect. But I'll request all our students to kindly keep the Sujata in loop. Whenever you are in contact with Dr. Kavita, you keep in loop Dr. Sujata or Dr. Rajesh, because Dr. Rajesh is the IPR coordinator of the IGNOS IIC, and Dr. Sujata is coordinator of Patent Facilitation Unit. So we should also know who is at what stage, because ultimately we'll have to help you all. And regarding this facilitation, supporting in filing your patent and these all things, this patent facilitation unit will certainly help you. So thank you very much, Dr. Kavita. And
Thank
I
you.
think we'll have to be in a very close interaction with you and your unit also in your institute. What kind of facilities are available for other students? You would like to know more in detail
Yes,
so
sir.
that we can inform our students also. our students are spread all over the country. So there may be some students who are in your area, there may be some other students. But in this technological day, at least we can be in connection through this technology, internet, web meeting, virtual meeting. So thank you very much for sparing time and addressing the students. And I hope many questions must have been addressed because this time we try to have it a very different kind of format. Because if you say anything that may not be interest of a student, that's why we had collected the questions which normally our students want to be addressed. So thanks to all those who have participated. And Dr. Rajesh, thank you to discovering Dr. Kavita as an expert for this. And
In fact, it was quite by surprise that I came across her name, even though she has studied in JNU where I had studied, but later on I came to know about her. So that's how I contacted her, and
in fact, yesterday you can recall there was this suggestion to create a pool of experts by the
yes,
regional directors
yes,
for IGNO, entire IGNO fraternity students. So you kindly keep her name in that pool of
sure.
experts,
Oh,
and
thank you so much,
I
sir.
hope she will agree to be
Of
a
course, no issues.
permanent mentor expert for IGNO students, because this kind of expertise should be shared. I think that will be helpful because we are always learning from people like you. So I will not take much time. Thank you, Dr. Sujata, also for coordinating these all things with Dr. Rajesh ji. So now you can take it
Thank
up
you so
further.
much, sir, for the kind words of appreciation. Thank you.
Thank you,
Thank
Dr.
you, Sharma
Sharma.
sir, for joining in.
Yeah, for joining in and sparing time for being with us, though you are on leave and you must be hard pressed with other things going on at your place. So, with your personal engagements, but thanks a lot that you spared some time. I would also like to thank Dr. M. Rajesh, RD, RC, IGNU RC Vatakara for organizing this session and being here with us for taking part. He is one of the coordinators for this session for PFU. I also thank our colleagues from RC Cochin and RC Vatakara who have joined in today's session, and they are there. They have spared their time being with us. I thank my colleagues from NCID, Dr. Josna Dixit, Dr. Momita Das, who are always the pillar of support for all the activities that are being undertaken at NCID, and also the background support, whether it is RC Vatakara or NCID, who have been working, Pawan especially, who has been working behind the scenes to make this possible. And lastly, our students, our innovator students, for whom we arrange this session so that their queries, their doubts are cleared. They get some insight because they are always asking us about all these questions. So we want them to create new products, services, come out with their innovative initiatives and be successful as entrepreneurs and have their own startups. So my best wishes are for them, and I hope they might have benefited from today's session. We will try to upload all the recordings of the sessions on the PFU website also. And ma'am, we would like to have you with us as an
Of
expert
course.
in
Of
our
course.
future, whatever initiatives we take. And thanks a lot for being here with us. And I really enjoyed this session because the way you explained all the things in such a simple and lucid manner, it was really good. Thank you so much. Thanks a lot to everyone. Thank you.
Thank you so much for giving me this opportunity. I should say special thanks to Sharma sir and Rajesh sir. It's very rare that we get into see these forums. I usually go to colleges for awareness classes, but with specific groups, it's very rare. Pan India, it's very good. But thank you so much for giving me the opportunity. And as I have offered earlier, I'm always available. Rajesh sir knows. He just sends me a message now. Kavita, we need to do this. I say, yes, sir, no issues. So thank you so much for that trust in me, sir. And thank you for giving me this opportunity. Sharma sir, Sujata ma'am, and Rajesh sir.
This
Thank you
is
so much.
basically true academics spirit
Yes.
to be ready for any academic contribution to the
Because
country
I just
society.
like teaching, sir. I mean, I always say that no one will stop me talking. That's why I took teaching. But then I like the profession as a like. So it's always a pleasure to be in any group or in any class.
In fact, a special word of thanks to Sujata Madam for doing such wonderful work behind the scenes, coordination, and definitely a lot of hard work she has put in. And definitely Sharma sir was the guiding force for all of us. And Kavita ma'am, as always, ready
Thank
to help us with everything. And such a proactive and positive force that we have in her, that anytime I feel free to approach her and request for her services. So thank you, all of you.
Thank you, sir. Thank you all.
Thank you, everyone.
Thank
So, may
you.
I leave the meeting? Yes. Thank you, sir.
Thank you.
Thank
Thank
you.
you,
Thanks,
Sharma sir.
thanks to all. Thanks, Kavita.
Yes.
In fact, this program is also live cast on IGNO RC Vadagara Facebook page also. So there also it is going live.
Oh, great, great,
So
great,
students are watching there also.
great.
Excellent. This is basically required because many students may not be
Yeah,
able to join in this
exactly,
way.
exactly.
They can watch it later on also.
That's
Thank
that's. Thank you so much. Sir. Thank you.
Thank you. Thank you, sir. Thank
Thank
you
you.
all.